Good evening, everyone. I welcome you all to today's webinar organized by Center for International Alternative Dispute Resolution, YCIADR, which is the first and only online dispute resolution center in Bangladesh, providing the most neutral, reliable, and cost-efficient dispute resolution service since 2018. YCIADR is now renowned for its fast rating dispute resolution and having the most experienced independent arbitrators and mediators in South Asia. Recently, it spread its young wing named YCIADR and acknowledged more than 600 plus registered student members of YCIADR throughout the whole country. ADR News, ODR TV, Research Center and Research Center and Conflict Resolution, ODR Institution, and Membership and Communication Department are the recently established six highly functional sectors of the CIADR. These sectors are headed by most enthusiastic and remarkable law students and young lawyers of the Bangladesh who signal their persistent passion to spearhead a new era of ODR development and expansion both for CIADR and global ODR ecosystem. Along with the large growing network all over the country itself, CIADR is now targeting to expand its network and open chapters in other countries like India, Nepal, Pakistan, as well as the African countries too. CIADR CIADR aspires to be provider for premium institutional aid as a tribal and independent venue for the conduct domestic and international ADR and ODR proceedings. CI-ADR webinar series is marking a path to create an actionable community and ensure solution to combat the future economic crisis in the global community. On behalf of Center for International Alternative Dispute Resolution, I will be hosting today's webinar. I am Lamia Khan Shipur. I have pursued my LLB from Daffodil International University. I work with the research team of YCIADR and president of YCIADR Daffodil International University chapter. The topic of today's webinar is Rule of National Court and Lex Fori International Commercial Arbitration. I will take few moments to discuss briefly about today's topic and introduce our today's keynote speaker. The question always arises on whether the intervention of judiciary in the process of arbitration is required or not. Judicial independence and intervention is also required in order to ensure fairness in the functioning of the arbitral process and for the protection of the interest of public. The court supervision is required so that the arbitral system should not be damaged. Both the arbitral system and judicial control should go hand in hand, and the balance is to be maintained. In this webinar, our honorable speaker, Ms. Harsita Ram, will canvass the rule of national court and Lex Fori international commercial arbitration and resolve the questions that what is a rule played by national courts in Lex Fori international commercial arbitration and what are the theories behind the judicial intervention. Ms. Harsita is the founder of Lex Apotheki, attorneys and international arbitrators. She has a successful international practice and handle issues in versatile domains. She is a licensed attorney in India and hold a master's in dispute resolution in international arbitration from University of South Wales, UK. She was the first recipient of the Corbett Scoring Memorial Prize for Outstanding Achievement in Dispute Resolution and was also nominated to the Dean's List. She acquired a fellowship from the Chartered Institution of Arbitrators CIARB UK as one of the youngest fellow in 2020. In early 2013, she became the youngest appointed member of the International Chamber of Commerce ICC Paris. She has held the position of District Manager, World Arbitration Organization WMO, and was a visiting scholar at the Indian Maritime University. She is panel arbitrator of the Commercial and Technology Panel of American Arbitration Association. Ms. Harsita has presented and co-presented several workshops, seminars, and training programs in India, UK, and US. I welcome our today's keynote speaker, Ms. Harshita, and thank you very much for sharing your valuable time with us. And the floor is yours now.
Thank you very much. Thanks for that wonderful introduction. Very good evening to all the participants in today's session. And thanks for having me address the topic National Court's involvement in international commercial arbitration. My greetings and best wishes to Justice Fried Ahmed, uh, Dr. Alam, the director of CIADR, and Mr. Odin, the secretary of CIADR, and finally Abdullah for having all the wonderful facilitation for today's session. The area of national courts and its involvement in international arbitration is not at all new and is always a complicated subject. National courts' involvement in international arbitration is a fact of life as prevalent as the weather, I would say, because the national courts become involved in arbitration for a whole lot of reasons, but primarily because national laws are permissive and parties invite or rather encourage them to do so. So, before we move into the topic, there are three very important questions that we need to understand. So, what is the nature of the involvement of the national courts, or the complement? Does the involvement of the national court complement or impede the arbitration process? So that's another important question. And finally, is there a place for any court involvement at all in the system referred as international arbitration? Because we just wanted to know if it's a myth or reality, right? So, yeah, so in our session today, we will discuss all these issues. And first, we need to understand the fundamental characteristics of international commercial arbitration as it coexists with national courts. So obviously, that's why we're doing this topic today. And next, we will look into the survey of different stages of national courts' involvement in the international arbitration process and the forms of court involvement. So also, we will analyze the court awarded injunctions that act to support the international arbitration process per se. And finally, we should be able to assess whether the court involvement is helpful to the process or is detrimental. I hope it's helpful to an extent. So, here we need to understand three very important terms in the role of national courts that play in international commercial arbitration. So the lex loci arbitri, which is a term where the place or the law of the place where arbitration is to take place, right? So generally, a choice for arbitration entails application of a lex arbitri, which governs the arbitral procedure and also provides safeguards ensuring the proper conduct of arbitration proceedings. And the next important term is Lex Fori. So it is the choice of rule of law, and it provides that the law of the jurisdiction or venue in which a legal action is brought, that is applicable. So lex fori simply means the law of court in which the proceeding is brought, while lex arbitri is the law of the place where the arbitration physically takes place. So, when understanding the role of national codes and lex fori in international commercial arbitration, uh, we are pretty clear that arbitration has grown into the preferred method, the most preferred method for resolving disputes, right? So, especially arising from international business transactions. So, this is mainly attributable to the recognition and enforcement of foreign awards, especially after the New York Convention. So, we all know that arbitration agreement is a special type of forum selection agreement that parties are required to stick to, right? And not to just litigate the dispute. But having said this, it's not correct to say that an arbitration agreement has completely deprived the judicial organs of any role in the arbitration process. So, which simply means that the court has a wide range of powers to assist and also supervise international commercial arbitration proceedings. Well, under international conventions and national statutes, courts should decline jurisdiction and compel arbitration if the parties already agreed to have the dispute arbitrated, if they have an arbitration agreement in existence. So usually it's a duty of the courts to basically compel or encourage them to pursue arbitration. So while that is in place, how does a court play its role? So how does it really intervene in an arbitration process, especially in an international arbitration process? So when the arbitration proceedings are pending, the court may step in and decide matters regarding appointment and removal of arbitrators. Um, in that case, the court may also order interim measures of protection in aid of arbitration. And obviously, after the award has been rendered by the arbitral tribunal, the prevailing party will have to move for recognition and enforcement of the award at the court. And we know that this process is, it could be either way. If the losing party, if when they fail to honor the award, the losing party can also oppose such a motion, or alternatively move for setting aside or annulment of the award at the court. So, in every aspect where the court can intervene in the arbitral proceedings, the court has to rely on certain procedural rules, which are mostly from the Lex Fori, that is the law of the forum state, the one that we just discussed, the aspect of the forum state, the law of the forum state, which is taken into account when the court really intervenes into the process of international arbitration. So, however, in international arbitration or in arbitration, in be it any arbitration, it's just party autonomy, right? It's a principle very well recognized in arbitration, and the role of the judicial authority has to be restricted. This is quite clear in ancestral model law as well, and most countries they follow the ancestral model law in and set up their own arbitration act, taking most of the relevant part of the ancestral model law. Also, under the statutes, the court cannot intervene in any arbitral proceedings except when it is statutorily permitted to do so. That is also very clearly given. But considering international arbitration being so developed and the public policy in its favor so advanced that the judicial role should be reduced, if not eliminated, right? Because it's not really possible to eliminate judicial role completely, but it's possible that it could be reduced to an extent, but where there's a necessity. Obviously, the judiciary will have to jump into give a clarification as and when required. But in reality, the answer to this is a negative because the court assistance is fundamental to international commercial arbitration proceedings, and it primarily fills in the blanks or rather gaps in international agreements or arbitration agreements, especially ad hoc agreements. Besides, the court's assistance shall conceivably be strengthened in response to the development of arbitration. So, when they jump in for assistance, so this is obviously possible, right? So, how do we apply Lex Fori laws to arbitration, and what is the principle or what are the procedures for that? So, for domestic arbitration, the court mainly relies only on national laws when deciding arbitration related matters. While in international arbitration, at least three different laws come into play because it's more complicated and people from different jurisdictions come under one contractual obligation and obviously have different choices of picking their laws. So what are the three different laws that come into play? So first will be the proper law of the contract or the applicable substantive law. So that's the very first thing. And the second one could be the proper law of the arbitration agreement itself. And the third aspect could be the law that is applicable to the arbitral proceedings or the lex arbitri. So, when deciding the validity of the agreement to arbitrate or other procedural issues, a court may not necessarily rely on the forum law, that is to say, the lex fori, because it's not necessarily the law applicable to the arbitration agreement nor the lex arbitri. But however, the lex fori is still the fundamental law as in many situations, because in many situations parties fail to subject the agreement or the whole arbitral procedure to a law of their choice, and the lex fori always applies on the subsidiary basis. So, in that case, it is very important for us to know the difference between the arbitration agreement and lex arbitri. It will be very risky to suggest that arbitration agreement always prevails when it differs from the lex arbitri. Uh, it's always suggested that the arbitrators must be very, very careful when drafting an award because sometimes they could end up in a paradoxical situation. So let's say, let me just explain that. Let's say, on the one hand, if they don't comply with mandatory provisions of the lex arbitri, then the award may be set aside, or they could even lose the benefit of the New York Convention sometimes. On the other hand, if they comply with those rules and thereby incidentally ignore the rules agreed by the parties, then the award may be refused recognition or even enforcement is not possible under the New York Convention. So it's always suggested that the drafters of the arbitration agreement shall be very cautious in making rules incompatible with the mandatory provisions of lex arbitri. So generally, the judicial role or the role of the judiciary with regard to arbitration agreement is quite convincing because we want them at some point to get the process going. The courts encourage the parties and honor their undertaking to submit to arbitration, and that's followed in almost all the jurisdictions. So maybe we could just see a few examples in like various jurisdictions. Let's take, for example, France. They have a code of civil procedure which is also applicable to international arbitration. See that's how they beautifully get the legislation done. So it also applies to the civil procedure code applies to international arbitration, and that's very encouraging, right? And also it states that if a dispute is submitted to an arbitral tribunal by virtue of an arbitration agreement that is brought before a national court, such court shall decline jurisdiction. See, this is really encouraging arbitration, right? So when something is filed before the national court, when it's taken before the national court, um, they can even decline jurisdiction, and that is even given in the civil procedure. So I think that's really nice, very proactive. And also, there is a provision in Chinese law and Chinese Arbitration Act. I think it was in the mid 90s that was passed. So it says like basically when the people if someone takes it to the court, they shall not accept an action initiated by a party to an agreement unless the agreement is considered completely invalid. So if the court presumes or if the court is of the impression that it is a valid arbitration agreement, then they really cannot get into the jurisdiction or entertain the matter. But if the agreement, only if the agreement is completely invalid, then they could really deny the arbitration procedure. So that's very encouraging. And also, the parties can make a request to the court. So the court can intervene upon the request of a party. So how does that happen? So under the New York Convention and most national laws, a court hearing is, hearing a dispute covered by arbitration agreement cannot declare ex officio like it has no jurisdiction. If a party brings a court action in breach of the arbitration agreement and assuming the other party does not challenge the court's jurisdiction, then it is clear that the parties jointly abandon the arbitration agreement. There is no like one side which is encouraging or which really want to pursue arbitration. So when both jointly abandon the arbitration agreement and the process, then such a joint intention will obviously be respected by the court. In that case, the court will refer the parties to arbitration, not just the defendant subjects to jurisdiction. So this approach has been widely accepted, and as I said, we saw the French and the Chinese law, the Civil Code, and the Arbitration Act of China, which was very encouraging. So everywhere it's clear that national courts are generally supportive of the arbitration proceedings. And this is just phenomenal because speaking of all this, we must know the court's role with regard to interim measures. Interim measures is a very important area where the national courts play their role. So, how does that happen? In international arbitration, parties sometimes seek interim measures of protection in order to facilitate the subsequent enforcement of the arbitral award, obviously, to facilitate the smooth conduct of the arbitration, or sometimes even to preserve the status quo of the dispute and prevent the prejudicial effect upon the parties. So issues relating to court-ordered interim measures are very important, and granting injunctions in one area of court involvement, it also cuts across every stage of arbitration process, and it can give rise to a number of practical and conceptual difficulties. So anti-arbitration injunctions are used either before arbitration has commenced. This is used mainly to prevent the tribunal from being established, or after proceedings have begun, to stop the arbitration process when the process is on its way. So that's how they use the anti-injunction process, arbitration process. And the injunctions restraining the conduct of arbitration proceedings are in general, and should only be granted where it is absolutely clear that the arbitration proceedings have been wrongly brought. So these injunctions can be directed against the parties alone sometimes, but also against the arbitrators if the court has jurisdiction over them. So either is possible. Could be against the parties, also against arbitrator, but we never know how the case would turn. So in general, there is a distinction between common law countries and civil law countries when it comes to the power of award anti-arbitration injunctions. Well, common law countries tend to be permissive, and therefore they are more willing to become involved, while civil law countries could tend to be restrictive and are reluctant to interfere in the process chosen by the parties because they totally respect the process of arbitration as party autonomy, and they completely respect the process, and they don't like to be interfered in the process when they think it's the party's choice and they should just stay away. But this is not surprising at all, given the two different, you know, systems, common and civil law systems. So it's just a way of thinking, right? And the risk of prose exaggeration or simplification of common law systems generally deal with parallel proceedings. Um, it is on a case by case basis by way of forum convenience. So but civil law systems mostly use the lis alibi pendens principle. That is, just to be treating the first come first serve, just like a first come first serve basis, and they don't like to be involved or intervened much in the process of arbitration. So that's the way the civil law countries handle. That's the system, right? So, whether ordering interim measures is in violation of the agreement to arbitrate, that is something that we need to discuss and understand. Well, in most jurisdictions, the granting of interim measures by the court is not deemed as a violation of obligation under the New York Convention. But there is a major jurisdiction that holds a somewhat different view, the United States, where courts are divided, right? So many different states, and the courts are divided with the views of, whether this particular interim injunction process is violative of the obligation under New York Convention or no. So, the United States courts are divided as to whether the interim measures may be granted in an international commercial arbitration setting at all. So, some courts in the US deny requests for interim measures, such as pre award attachments, on the grounds that it is contrary to the parties' agreement. But there are also other courts of the United States with a different view that that where the parties of pre-award attachment as a type of preliminary remedy. So the views are just not uniform. It's quite divided, and some support the view that it is obligated under the New York Convention, and some don't. They think they have to just go with the process. But once we process or pass on the stage, and when the real award is passed, then is the review of arbitral awards. So, how does this process take place? There is a court review of arbitral awards. So mainly two types of reviews and applicable laws are made. And usually after an international arbitral award is made, it is widely enforceable under international conventions. However, the universal enforceability will not be conceivable if the court really cannot exert any review upon the content of the award and also the procedural context in which the award has been made. So the court review takes place either at the seat of the arbitration or the country under the law of which the award was made, let's say where the losing party requests the court to set aside the award, or in certain places where the recognition or enforcement of the award is sought. The law generally to be applied in this kind of setting, side proceedings in the lex arbitrate, which is either the law of the seat of the arbitration or the law under which the award was made. So generally, the applicable law to the recognition or enforcement proceedings is that of the country where the recognition or enforcement is sought. So that's including international conventions of which the country is a member, as those conventions has been incorporated into the national legal system of the member country. So a portion of it is also taken as national laws. So it is all interlinked, right? Also, as has been mentioned in the proceedings, when deciding certain issues during proceedings, the applicable law will lead the court to adopt a different law. So this is usual. So when the proceedings go on, when the case commences, there it could take a twist and turns. So let's say, for example, the court may also apply the law of the party's choice as to the validity of the arbitration agreement because they were the one who construed the agreement. So usually it is determined in the best interest of the parties. And also, there could be grounds for refusing recognition and enforcement, and grounds for setting aside. So, how do the national courts really deal with this? For international arbitral awards, the judicial authorities in the member states of the New York Convention and may only refuse the recognition or enforcement upon grounds expressly provided. There's Article 5 of the convention which speaks about this. The list of grounds is exhaustive and it excludes any revision of the merits of the award. Sometimes the New York Convention also talks about the public policy grounds where the parties, when they apply on the basis of public policy that this particular arbitration is violative of public policy, and when they apply to the court for interim measures, there is also a possibility that the court might not even let the tribunal to be set up even before the proceedings commence, right? They wouldn't even let the tribunal to be set up if they really think it's against public policy. So, as I said, it's just exhaustive. The grounds are exhaustive. But though the court may take a more liberal stance as to declining the request for refusal, certain grounds still exist and just do not deny recognition or enforcement on a ground other than those listed in Article 5 of the New York Convention. Um, so there is also another very important concept called the delocalized awards, which we need to understand when knowing about the role of the courts. Let's say for the past 2 3 decades, I would say, yeah, maybe 2 3 decades, there is a new trend in national legislations towards delocalization or denationalization of international commercial arbitration. Um, so we did speak about the French and the Chinese law, and there is also a very interesting provision in Belgium Judicial Code, where the Belgian courts can only hear an action to set an award aside if at least one of the parties to the dispute decided by the arbitral tribunal is either an individual having Belgian nationality or residence, or it could be a legal entity that is constituted in Belgium or having a subsidiary or other establishment in Belgium. So what does this basically say? This gives us an understanding, this gives us a very clear picture where the judiciary is trying to narrow down as to who can be heard in a matter of arbitration. So here they say it could be parties with citizenship, Belgian nationals, or someone that is a resident, or someone that has an entity in Belgium, or a subsidiary, or some connection, not just any other person can go apply for it, right? So they are restricting, that's kind of narrowing down the scope of applicants and parties reaching the court. So this is also bringing an affiliation towards a nation and to its citizens, giving them priority and also taking their concerns into account and honoring it on priority basis. So not just any other person is encouraged, right? No other outsiders are encouraged. So they set out a criteria for who should be and who should not be heard, or whose application per se should be considered for such a measure, for such an interim action. So I think this is very encouraging and very nice, a very nice act of the judiciary to bring out the spirit of encouraging alternative dispute resolution. Also, when the enforcement of an award, when that aspect comes into play, after an award has been set aside in the state where the arbitration took place, it nevertheless be recognized and enforced in another state. So it has been argued several times that the setting aside of an award eliminates only its enforceability in the same state, not the existence of the award. And it also says that it could be further enforced elsewhere. But this particular principle is subject to a lot of criticism, and also this argument has been recognized by some jurisdictions, and some don't really recognize this because this is also kind of paradoxical. As I said earlier, on the one hand, you say when there is a setting aside of an award and the award is completely not able to be enforced, that kind of limits the scope of the award, right? So sometimes it could even nullify the award. But some also argue saying that it only eliminates the enforceability in that particular state, and you should in reality accept that the award actually exists and the existence cannot be denied because the procedure, the arbitration process actually took place. There was a dispute that was decided by the arbitrator and there was an award that was passed. So it's existence per se cannot be denied just because its enforceability was eliminated in one jurisdiction. So some jurisdictions do encourage this. Again, the views are divided, and some really don't encourage the views that the award, once is not enforceable, can again be taken into account as to its existence. Yeah, people have different views about it, and it really depends on a case to case basis. And another very important question is whether enforcement, despite procedural irregularities, we do have procedural irregularities in arbitral procedures. Not very often, but it does happen. So the arbitral procedure, when is faced with irregularities, how do we really do deal with it, and how does the enforcement take place? So the arbitral procedure is conducted in accordance with the parties' agreement and the procedural law of the arbitration. So generally, if the procedure is not in compliance with the agreement or the procedural law, the award subsequently rendered may be set aside, or its recognition or enforcement can be completely denied or refused. But will the award be doomed upon even for minor or non-compliance? That is something where the courts take a stand, and they play the role to decide whether it has to be completely doomed, or whether the minor alleged non-compliance of the award can be ignored and still given priority, given respect, and given a chance for enforcement and recognition. So that's where the court play their role to decide those. And um, this is not a very settled area because it's completely on the court, and it's their discretion to ignore a minor compliance, non-compliance, or to really accept and deny the interim measure. So it's the court's discretion in this area, because there is no settled rule here. It depends on case-to-case basis, and it's the court's discretion. Although party autonomy has been widely recognized as the underlying principle for international commercial arbitration, the procedural rules contained in Lex Arbitrate or Lex Fori in most circumstances, the court assistance and intervention are still indispensable for the success of international commercial arbitration, and to even enforce the procedure, to encourage the procedure of international commercial arbitration. Because the national courts will have to be more supportive and very encouraging to enable the parties to pursue the process. So far, there is no sign of diminishing judicial role in assisting international commercial arbitration. Although in some jurisdictions, the courts they just tend to be very relaxed, and it's intervention upon the arbitral process. But recently, most jurisdictions, and also if you look at the arbitration legislations and court decisions in most jurisdictions, they all indicate a very emerging trend in growing in favor of international commercial arbitration. So it's always important for us to understand that the national laws will have to support and aid the process of arbitration, and let the arbitration process function independently. So we're not saying that we don't want the intervention of the judiciary at all, because, as I said, sometimes when interpreting ad hoc arbitration agreements, we do need the assistance of the judiciary. But Also, it would be nice if they have the international arbitration procedure has an individual and independent functionality for a better recognition, and so the parties are also very comfortable in choosing that. So I think that is the success of encouraging the process of arbitration, and also getting the burden from the national courts. So yeah, that's about it. And thank you very much for the opportunity. And I hope this was helpful. And yeah, if you have any questions, please. Thanks.
Thank you so much. And we still do not have any questions.
Mm-hmm.
Uh, thank you for your today's discussion. We are completely clear about this topic, and it is very much helpful for the young lawyers. And thank you so much. And every topic and every point is so clear to us.
Thank you so much.
Thank you so much. There is a question that what is the condition to invoke international commercial arbitration? There is a question from viewer
Okay,
Maria
so
Hussein.
okay, thank you. Thanks for the question, but I'm not quite sure what she really means by condition to invoke international commercial arbitration. So our topic is mainly about. Oh, I think there is a continuation, or it's a different question. It's a different
This
question.
is yes, different
Okay,
different question.
okay, let me answer her question. So there is no condition as such. So here we are talking about the role of national courts and how the national courts can really interfere in giving interim measures to an existing or ongoing international arbitration, or even before commencing an international arbitration. So when there is a doubt in the arbitration clause, then for clarity in ad hoc arbitration agreements mostly. So we can approach the court for more clarification. And as I mentioned about the anti-arbitration injunction, even if you think that this arbitration procedure or this particular arbitration is not the right one to commence or to be um, set up, then the parties or either of the parties can approach the court and get an interim order for not setting up the tribunal at all. So that is possible. So there is no fixed condition. It really depends on case to case basis. But there is national courts always to the rescue if there is any confusion for the parties in ongoing process of arbitration. Thanks. I hope that helps.
Thank you so much. There is another question. Is an arbitral tribunal permitted to rule on the questions of Lex Fori jurisdiction?
Yeah, Lex Fori is taken into account as I mentioned, right? So Lex basically there are a lot of at least three different laws are involved in international arbitration, as I mentioned, because obviously two parties from different jurisdictions, and then sometimes they choose the substantive law and the procedural law. So yes, Lex Fori is taken into consideration, and Lex Arbitri is also taken into consideration. Mostly, the party's intention of drafting that particular clause, and also the intention to choose the specific procedural and substantive law is given uh, uh, given a lot of importance by the court, and that's how they determine which exact law to proceed with when it is taken to the national courts.
Thank you so much, ma'am. This
Okay.
is very helpful. I think those who were asked the questions, they got the exact point, exact answer. Thank you so much, ma'am, for
Thank you.
today's session.
Thank you very much. Thanks for inviting me today to address your audience, and I hope to collaborate with you in the future. And thanks a lot, and best wishes to all the student members that also participated today. Thanks a lot.